Earlier this year, when I started the bar year, we launched a weekly chair chat to talk about different topics around civil rights and social justice. I took on the task of hosting this chair chat every week, every Wednesday, and I just want to acknowledge the first guest we had as a chair chat guest, our president of the American Bar Association, Deborah Enix Ross, who's here tonight. Thank you for being with us tonight. And thank you for being a partner and a friend to us this bar year. And now I have the distinct pleasure to introduce someone who needs no introduction, someone who I call a dear friend, and someone who I'm told by Deborah at 1 o'clock on Tuesday, I can call the president of the American Bar Association. As of Tuesday, my dear friend, Mary Smith. Come on up, Mary.
Well, good evening, everyone. I'd like to acknowledge Juan, my dear friend, and for a successful end to his year as chair of the section of Civil Rights and Social Justice, and to our outstanding president, who I am honored to follow, Deborah Enix Ross, and of course our wonderful ABA Medal Award winner who gave us inspiring remarks earlier today, Mr. Gray. I'm also so happy to be here to honor my dear friend, John Echohawk, who will receive the Thurgood Marshall Award for Champion Civil Rights for Native Americans. John is only the second Native American to receive the award. The first Native American to receive the Thurgood Marshall Award was another friend, Lawrence Baca, who's also here tonight. Thank you, Lawrence. Now, many of us remember, while some of us have only read about, and then some of us have lived it like Mr. Gray, the civil rights era of the 1960s, the era of the Voting Rights Act, the era of Martin Luther King Jr. What you may not realize is that the early 1970s was also an era for American Indian civil rights. The Indian Civil Rights Act was passed in 1968. In 1975, the Indian Self-Determination and Education Assistance Act was signed into law and made self-determination the focus of the government. The act reversed 30-year effort by the federal government under its preceding termination policy to sever treaty relationships with and obligations to Indian tribes. The act was the result of 15 years of change influenced by American Indian activism, the civil rights movement, and grassroots political participation. It was against this backdrop that John Echohawk had the audacity, yes, the audacity, to form the Native American Rights Fund that would be dedicated to fighting for tribal sovereignty and Native American rights. NARF is essentially the law firm for Native peoples. It was a halcyon era, a transformational time. Since that time, the rights of Native Americans have ebbed and flowed in this country. There have been major legal victories like the Cobell case, which was also handled by John and NARF, but there have also been disappointments and setbacks. It is fitting then to look back at the evolution of Indian law and reflect on where we are today. The first Justice Marshall laid the foundation for Indian law in this country. And Indian law, in my opinion, more than any other area of law, dovetails with the history of our country. In the 1820s, U.S. policy toward what was regarded as the Indian problem was one of forced removal and resettlement to lands in the West. In 1830, Congress passed the Indian Removal Act, signaling a determination to effect great changes. The Cherokee, that's my tribe, faced with growing hostility to their presence in the state of Georgia, were the first group of Native Americans to press their legal rights all the way to the U.S. Supreme Court. The court issued decisions in two cases that are commonly known as the Cherokee cases. Chief Justice Marshall, writing for the majority in the second Cherokee case, pointed out that from the beginning of the Republic, Congress had enacted a series of laws to regulate trade and intercourse with Indian American tribes. The laws treated the tribes as nations, respected their rights, and sought to give the tribes the protection that the treaties stipulated. He concluded that Indian nations are distinct political communities having territorial boundaries within which their authority is exclusive, and having a right to all the lands within those boundaries, which is not only acknowledged, but guaranteed by the United States. That legal pronouncement by Chief Justice Marshall is still the foundation of Indian law today. A few decades later, another significant Indian case was decided. It is like the Brown v. Board of Education of Indian law. In Standing Bear versus Crook, Chief Standing Bear made a statement in his own defense in his habeas case. As the trial drew to a close, the judge announced that Chief Standing Bear would be allowed to make a speech in his own behalf. Raising his right hand, Standing Bear proceeded to speak. Among his words were, "That hand is not the color of yours, but if I prick it, the blood will flow, and I shall feel pain. The blood is the same color as yours. God made me, and I am man." It was in this case that the federal court ruled that an Indian is a person for the first time in federal law. Fast forward to more recent times. This dinner is named after Thurgood Marshall, a great champion for civil rights from his time litigating Brown v. Board of Education to his jurisprudence on the court. Something that has rarely been discussed at this dinner is the role of Thurgood Marshall in federal Indian law. One law professor has calculated that cases involving federal Indian law come before the U.S. Supreme Court at a rate higher than other unique area of law. For 3 decades in Indian country, we asked, who wrote the opinion? Because if it was assigned to Justice Thurgood Marshall, you could pretty be sure the case was decided in favor of Indian interests. During his time on the court, Thurgood Marshall wrote 14 opinions in cases involving federal Indian law. In 1978, Justice Marshall wrote his most powerful and controversial federal Indian law opinion. Santa Clara Pueblo versus Martinez involved a challenge under the Indian Civil Rights Act of 1968 to the tribe's restrictions on the enrollment of children of female members of the tribe who had married non-members. The children of male members of the tribe married to non-members were granted enrollment by the tribe's law. This case, it was a classic case of gender discrimination and a challenge both to the tribe's right to declare its own membership roles and its sovereign immunity from suit. As Professor Rebecca Sosi has written, the key to the Martinez decision then is Justice Marshall's choice to treat it as an Indian law case rather than a federal civil rights case. In specifically addressing the question of membership, Justice Marshall wrote, "A tribe's right to define its own membership for tribal purposes has long been recognized as central to its existence as an independent political community. Given the often vast gulf between tribal traditions and those with which federal courts are more intimately familiar, the judiciary should not rush to create causes of action that would intrude on these delicate matters." Just a few weeks ago, the American Indian community celebrated and, being honest, breathed a sigh of relief in the Brock Keene case involving the Indian Child Welfare Act. The Indian Child Welfare Act was enacted specifically to counteract decades of Indian children being removed from their families in an effort to strip them of their culture, their identity, and to assimilate them into white culture. I will leave you with a powerful quote from the Brett King case from Justice Gorsuch. In a concurring opinion, Justice Gorsuch wrote that when enacting ICWA more than 30 years ago, Congress exercised its lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. I think tonight demonstrates that we are far from fading into the twilight of history. Indian communities are alive and well. Indian communities are resilient. Indian rights are human rights. Thank you so much.